So good afternoon, everyone. I am Lisa Pop. I'm Project Director for the Indiana Deafblind Services Project, and I want to welcome you to this afternoon's virtual workshop on special needs trusts with Gordon Holmes. I'll give it to Gordon and let him get started and introduce himself to you.
Wonderful. Thank you so much. I appreciate that. Appreciate everyone joining in today. The topic for today is special needs trusts, and this is not your grandfather's trust that we're talking about. So I think there's going to be new information for everyone. In fact, we're going to do a deep dive into special needs trusts. And so if you were looking for anyone to be on the meeting today or call and they're not, you might want to text them or reach out to them, because this is really going to be a unique opportunity to understand the various types of special needs trusts and what problems they solve. I love this topic. It was so hard fought as a special needs community to have these wonderful options, and it's really inherent upon us to take full advantage of them as we advocate for our loved ones that have special needs. So again, I'm Gordon Holmes, and I'm a certified financial planner and a special care planner. So my practice focuses almost exclusively on special needs, helping families that have a member with special needs deal with the legal, financial, and government benefit issues. So today we're on special needs trusts, and I'm going to share screen and go to the PowerPoint. And here we go. Boom. Maybe there we are. Okay, so I've tried to make sure I've got everyone in that was waiting. So I think we're current, we're ready to rock and roll. So special needs trust, providing for lifetime care and quality of life. Disclosures, we're not all things to all people. And then there is the MassMutual Trust Company disclosure as well. And now we're into the material. So Special Care is a division of MassMutual, the large financial and insurance firm. And through Special Care, we have a group of highly trained individuals like myself across the country that are serving in their respective special needs communities. So my geography is the entire state of Indiana and most of the state of Kentucky. And so we have expertise, both legal, financial, government benefits for both states. And then I have peers across the country that serve in other states, et cetera. All total, I think there's close to 300 of us. And we're trying to be a force for good. Working with families, many of us have family members with special needs. I have a child on the autism spectrum with Crohn's disease and other challenges. So I'm certainly well familiar with the journey. Okay. So when we talk about special needs trust, we're going to lead off by what are circumstances that might bring about the need for a special needs trust, meaning, you know, who would be interested in such a thing. And so this is a bit of a laundry list of situations that cause a special needs trust to come to mind. One would be a special needs trust for an individual with intellectual or developmental disabilities. That's a very common use for a special needs trust. Also, congenital disabilities. Someone that has sustained a traumatic brain injury or spinal cord injury. And in fact, just in the last week, I've had meetings with families that have both. Someone that had a traumatic brain injury actually as a result of a brain tumor and surgery, and then someone that has a spinal cord injury. Yep, we see those certainly. Medical malpractice situations, which usually result in litigation and then ultimately a settlement. Those are involved with special needs trusts. Also, personal injury liability situations where someone has been injured and again, there's litigation and a settlement. Manufacturer liability, that's where the the car didn't work like it was supposed to, or some product went awry or was a problem. Someone gets injured, someone is hurt. There is determined to be liability. And then a settlement is forthcoming. So structured settlements, another example. Structured settlements are where there is a settlement, and the settlement, perhaps as opposed to a lump sum, comes in the form of a string of payments. So that string of payments can go to a special needs trust for an individual with a disability. Special needs trusts are very much a part of inheritances. So where an individual inherits from parents or grandparents or someone else, or receives a gift. And we will talk about many of these varied situations as a part of today's workshop, and there are even a few examples thrown in to look at. Where there's Medicaid and or SSI eligibility issues relating to income or resources, special needs trust can save the day. So part of the motivation for special needs trusts are to either enable someone to be eligible for government benefits where they are currently not, or in order to maintain eligibility for benefits that they already have. And then in addition to that, as a tool to help manage one's financial resources so that funds are not frittered away or that they're not taken advantage of. So again, a lot of motivations for utilizing special needs trusts these days. On the government benefit front, government benefits are largely dropped into two different buckets, and you see the buckets listed here, bucket 1 and bucket 2. Bucket 1 is pension or insurance type of government benefits. And these are the benefits that are not means tested. What that means is that these benefits are available and the amount of assets that you have are not a deterrent to qualifying. And certainly the most popular among the pension or insurance type of benefits are the Social Security Disability Insurance, or SSDI as it's so often referred to, and also Medicare. Medicare goes with SSDI, and you may or may not be familiar with Medicare for young people, but it's possible for someone in their 20s to be on Medicare. And this is typically when they have, for whatever reason, met the criteria to be eligible for Social Security disability, not SSI, but SSDI. And as a result of that, Medicare comes along afterwards, usually with a wait of 24 months. So that is the SSDI starts. And with the start of SSDI, the clock is moving. And after 24 months on SSDI, typically Medicare is automatic. That does not mean that they lose Medicaid. In most cases, Medicare is added and it becomes the primary insurance. And then Medicaid is retained and it becomes the secondary or backup coverage to the Medicare. Then there are needs-based benefits or needs-based type of benefits. And these do strongly reflect income and assets, et cetera, as far as eligibility are concerned. So SSI, Supplemental Security Income, is a monthly stipend for food and shelter. No doubt you're familiar with that. It can be available from birth to grave, but prior to the age of 18, a family's financial circumstances do weigh in on the eligibility for or availability of SSI. With SSI comes Medicaid, just like Medicare comes with SSDI. So SSDI is a monthly stipend for living expenses. Medicare becomes the sidekick there for health insurance. SSI is a monthly stipend specifically for food and shelter. And with it comes the sidekick of Medicaid. Now, in Indiana, there are approximately 20 types of Medicaid. And this afternoon's workshop is not focused on solely on Medicaid, but we are a 1634 state, and as such, we're in a majority with other states. Over 30 states have signed on to the national guidelines. And as a result of that, in Indiana, with SSI does come eligibility for Medicaid. If someone has a Medicaid waiver among their government benefits, then they typically have a different type of Medicaid than that comes solely with SSI. And that's what we usually refer to as disability Medicaid. And there is a difference. There's a difference in the quality of coverage. And there certainly is a difference with disability Medicaid that comes with a waiver from the standpoint of the amount of income, that is overarching income, that a recipient of waiver services is allowed to have without losing their Medicaid. So this is really important stuff. So if someone has a disability and they have SSI and Medicaid, but they do not have a waiver, then most likely they will be receiving indigent Medicaid, not the same as disability Medicaid. And unfortunately, if they took a job or started to generate some income, they may find themselves on the short end of the stick. Disability Medicaid is much more forgiving on income, as we'll see a little later. I want to pause and remind everyone that questions are not only allowed, they're encouraged, they're welcomed. And so as we are covering material, feel free to click on the little icon called chat that looks like something from a text on a cell phone, and type in your question into the chat box. And then when I notice a question is there, I'll do my best to answer it right away while we still have the slides up pertaining to that particular area. So as opposed to, we have a smaller group today, so as opposed to waiting to the end, feel free to throw your questions in chat as they come to you. So a few did you knows. Number one, individuals with special needs who may qualify for both Medicaid and SSI may not receive these government benefits if their assets exceed $2,000. And the government counts just about everything. So, so if they have more than $2,000 in a savings account, a mutual fund, an IRA, anything that's cash or can be easily converted to cash, then they cease to be eligible for the key benefits of SSI, Medicaid, and by extension, Medicaid waiver services. However, please keep in mind that SSDI and Medicare are not means tested. Therefore, they are not subject to the $2,000 resource limit. But even for those that, as they get further into life, become eligible for SSDI and Medicare, that $2,000 resource limit continues to exist because of their participation in Medicaid and Medicaid waiver services. So for that reason, $2,000 for an individual, $3,000 for a married couple is the resource limit. It applies to SSI, Medicaid, and again, waiver services as well. A strategy in some situations is to place assets, including inherited or inheritance gifts, life insurance, etc., in a carefully drafted special needs trust. So if a special needs trust is set up properly, then it is possible for what would otherwise go to the consumer directly to be redirected to, again, their special needs trust. The objective with the special needs trust is to create a safe haven where assets can be placed that do not count against the $2,000 resource limit. Now, I know that we've had a discussion about ABLE accounts in an earlier session. So a reaction may be, well, what do we need with special needs trusts anymore? Now we have ABLE accounts. Well, the key is just how much money are we talking about? Because ABLE accounts have a maximum annual contribution limit of $16,000. That's $16,000 as of January 1st of 2000, 22 when the annual gifting limit went, after years of being at 15,000 to 16,000. And so as a result of that gifting limit increasing to 16,000, the individuals are eligible to have as much as 16,000 placed annually in their ABLE account. So again, you might say, well, what do we need with a special needs trust? We have ABLE. Well, that limit on ABLE, that 16,000, really makes it useful in certain situations, but not all situations. Because if assets are being inherited that are over 16,000, then you're not going to be able to use an ABLE. That 16,000 is a limiting factor. Or if the individual's disability originated after the age of 26, then they're also not eligible. Just some examples of where special needs trusts really make a difference. All right. So special needs trusts largely go back to what's called OBRA 93, which is the Omnibus Budget Reconciliation Act of 1993. So they've been around for 28, 29 years. It took several years for the public to, or special needs community to latch on to what Congress had done, which is amazing in passing this legislation. Interestingly enough, OBRA 93 also included language that made it all but impossible for a senior citizen to hand off their assets to a child in order to qualify for Medicaid. So there were winners and losers with this legislation, but for the disabled community, very much a winner. There are first party and third party special needs trusts. So we're going to get into a conversation of the different types of special needs trusts a little later, but it really depends upon what problem you're trying to solve as to which trust is most appropriate. Okay, a means of enhancing an individual's quality of life beyond basic food, shelter, and healthcare provided by the government. That really sums up what a special needs trust is or what it's designed to do, enhancing an individual's quality of life. It can be set up to send a dependent with special needs to camp, take vacations, travel to visit relatives, buy sports equipment, pursue education, such as job or technical training, college, or to pay for other therapeutic needs that do not fall under day-to-day living or maintenance expenses. Dental care, purchase of a house, a condominium, furniture, clothing, personal items, entertainment, etc. So a lot of things here in the list of what a special needs trust can pay for. Very, very broad, the range of things that withdrawals can be made from a trust to pay for. Right before I hopped on the call this afternoon, I got an email from someone who wants to buy a motorized wheelchair for his son with special needs. And he has had a terrible time with Medicaid. They ordered a chair and then it was not electric. Problem after problem after problem. And in the meantime, his son's health is deteriorating. So he reached out to me and said, let's have the trust buy him what he needs because the government can't seem to get it done. So we're going to purchase a motorized wheelchair for him. And through that, he'll be able to get out and enjoy the spring days and the warmer weather and so forth. So very much a positive thing. I'm frequently asked, what can we do with the funds that are in a trust? And the answer is that they can be invested. So funds held in a special needs trust can be invested to grow and build for the future. Also, if properly drafted, proceeds placed in the trust will not affect government benefits. So there is no $2,000 limit with special needs trusts. Assets placed in the trust can grow and build. And if they exceed the $2,000, then they're not a problem for maintaining benefits for the trust beneficiary, et cetera. So who should establish? A caregiver or donor can establish a third-party trust for a child, a sibling, or a loved one who is disabled, or anyone who asks the question, who's going to take care of them, or how can I pass on a part of my estate without affecting their government benefits? So lots of reasons for special needs trusts. All right, so the goals typically for setting up a special needs trust include coordinating available resources to make sure that there's good financial oversight, ensure continuation of government benefits. So I know that government benefits continuing on is so very important because without those benefits, there's a large burden that falls upon parents or family, this type of thing. And you just want to keep the services going, et cetera. So providing supplemental needs for life, improving quality of life, and then directing final distribution. So a special needs trust does all of these. Okay. The special needs trust stipulates how the monies contributed to the trust are to be used for the beneficiary. So whoever sets up the trust gets to have a say. In other words, state-specific language is necessary. So the legislation varies by state for special needs trusts. The trust names a trustee who is responsible to carry out terms of the trust agreement. That's the trustee. Typically, whoever sets up the trust can first serve as trustees, such as parent or parents, that type of thing. There are many ways that a special needs trust can be restricted or can be created, excuse me, to fit the needs of the family. Okay, so here we are looking at the different types of special needs trusts. And we will talk about each of these individually because they all solve different problems. So based on the circumstance of the trust beneficiary or consumer with special needs, it makes a difference as to which from our reservoir of options we select. So first of all, first party special needs trust is listed, and a first party special needs trust as opposed to a third party special needs trust further down is whose money is going in the trust. So first party special needs trust welcomes the funds of the consumer with special needs. So first party special needs trust is typically used when the individual with special needs either has money that we need to do something with, or we're wanting to direct funds that are coming to the individual to the first party trust so that they do not block continued eligibility for government benefits. So that's a first party trust. Usually functions under the trust beneficiary's social security number, and those funds are available to the trustee to pay bills for the special needs individual or the beneficiary. So those funds are available. So first party usually is used to set aside funds belonging to the trust beneficiary, and that's why it's first party as opposed to third party. Self-settled special needs trust is a first party trust that's actually set up by the individual with a disability. They're allowed to do that for themselves if they have capacity. Special Needs Trust Fairness Act, that's the legislation that brought about the self-settled special needs trust where the individual with a disability can set up their own if they have capacity. Third-party special needs trust is a special needs trust that's designed for anyone's money except for the individual with a disability. So mom and dad, siblings, anyone, you name it, and they can make deposits to a third-party special needs trust to build a reservoir of funds to assist with whatever the government can't or won't pay for. So the government's primary focus is on food, shelter, and clothing, and the special needs trust is the person's everything else. So we see as an example, different reservoir of funds to help someone. So government benefits is one, again, with a focus on food, shelter, and healthcare. And then second might be what the consumer is able to generate as a result of part-time employment. Third, we can have funds from a special needs trust kick in to help pick up the slack or make up the difference. And so it's funds coming from a variety of sources that come together to help support or sustain the individual with a disability. A qualified disability trust, that's a trust designed to help minimize taxation situations where that's a concern. And then pooled special needs trust. The most popular is the ARC of Indiana Trust here in Indy, and this is walking through the different parts of the trust to see what can be done, pooling resources together, setting up the trust. And so everyone participates in a legal trust document with a pooled special needs trust. So again, the ARC has ARC Trust 1 and ARC Trust 2, and that can be an option, especially when one is not certain who can serve as trustee. Sometimes the ARC can serve as a backup trustee where mom or dad or a combination of mom and dad are the trustees, and then upon their passing, the trust defaults to an ARC trust arrangement. Then there's Miller trusts, and Miller trusts are really exciting because Miller trusts are there to solve income issues. That is to make certain that the individual with a disability does not have so much income that it blocks their eligibility for specifically Medicaid and by extension Medicaid waiver services. So we'll look at some examples of these. Okay. All right, so for a first party trust to lead off, self-settled trust typically funded by monies belonging to or being received by the trust beneficiary, thereby staying under the proverbial $2,000 resource limit. So this is money that comes by inheritance or any measure of situations, and it's put them over $2,000, and they know they've got to do something with this money, or they're going to lose eligibility possibly for SSI or Medicaid, waiver services, et cetera. And so they take advantage of the option here to set the funds aside in a first party trust. They can be invested, they can grow. If they have no expenses now, then what's in? If they have no expenses now, then what accumulates in the trust can handle future expenses. And again, the range of things that a special needs trust can cover is very broad to assist the trust beneficiary. Okay. So we, let's see here. I'm able to get back in. Okay. All right. So we had someone rejoin us. That's wonderful. Okay. So a first party special needs trust can be established by several different parties. It can be established or settled by a parent, mom or dad, or mom and dad, a grandparent. It can be established by a court appointed guardian, the court itself, or as of December 13th of 2016, as a result of the Trust Fairness Act, a special needs trust can be set up by a competent trust beneficiary. They cannot serve as the trustee, but they can set up a first party special needs trust. Beneficiary must meet the strict definition of disability for a special need, for a first party or self-settled special needs trust. And the trust is irrevocable, and the beneficiary is generally under the age of 65. So the first party special needs trust is not designed for someone that's 85 going into a nursing home that wants to set aside their lifetime savings in order to have Medicaid pay the bill. It's reserved primarily for individuals under the age of 65 and where they are trying to keep their resources under $2,000. and they're earning, they're either earning income or they're receiving it as a gift or settlement or something, but their income, their total resources are going above 2,000, and they need to offload those resources. So again, first party trust is for resources belonging to the consumer with special needs or disability. After the beneficiary's death, the state is reimbursed from the trust for Medicaid benefits paid during the lifetime of the beneficiary. So this is what we call a Medicaid payback. So upon the death, again, of the consumer with special needs, the state will seek to reimburse themselves from what's left in the trust for benefits afforded them while they were living. Trust exists for the sole benefit of the disabled beneficiary. So this is not them and 20 of their closest friends. The trust exists for them. The trust can certainly pay other people to provide services to the individual with special needs. The trust can also pay for someone to accompany them if it simply is not safe or possible for them to travel on their own. It's designed to supplement, not supplant government benefits. Okay, yeah, I think we got that pretty good. So that's first party trust. Again, the key is with first party trust, we're talking about assets coming to, owned by, or being received by the individual with a disability. This is not for other people's assets, it's for their assets. So let's look at some examples here of where a first party trust may be particularly helpful. The first example one is a traumatic brain injury. Oh, and by the way, I should offer that all of the examples that I share in all of the workshops are as a result of specific situations where I helped families. So none are made up. They're all from real life stories or situations. Makes them really, really special. So example one, a traumatic brain injury or TBI at the age of 12. And the person receives a monthly allowance. So that's a real life situation. A person was unfortunately injured in an auto accident, did receive a settlement, the funds were invested. And now the investments in that first party special needs trust generate income monthly to the trust beneficiary. And as a result of that, that monthly allowance keeps that person out of a shelter. So that allowance enables them to cover food, transportation, and apartment rent so that they have a reasonable quality of life. It's really an amazing situation there on that one. Okay, we have somebody joining us. We'll try to get, there we go. Okay, so again, that was example one for someone at age 12. Example two, someone disabled at 32 with no government benefits. So this is someone that was out there working and doing great, and then something happened. You know, they had a disabling event, and that caused them to have to stop working. And they're 32 and there's no government benefits. So no government benefits have been applied for or obtained. So using a first party special needs trust will be a way to offload assets from the person so that they can become eligible for Medicaid, Medicaid waiver services, possibly disability income, Social Security, et cetera. Health issue at age 40, special, let's see here, Social Security, disability income, and Medicare, but need Medicaid and waiver. So this is someone that became disabled, qualified for Social Security, disability, and Medicare, but they're needing waiver services. So they need to apply for the waiver and for Medicaid. But resources have to be under 2,000 to be eligible. Let's see here. Part-time employment and single, living with parents, needing funds. They need waiver services. So they're working part-time, but they need help. Age 21 with a UTMA account. So if they're 21 and they have a Uniform Transfer to Minor Act account, that account becomes treated as an asset of theirs and undermines their continuing eligibility for Medicaid, SSI, et cetera. So the first party special needs trust can rescue that situation. And then on a funny note, winning a lottery, a ticket, or sports betting winnings, believe it or not, if they get lucky, those funds received can cause them to lose benefits worth hundreds of thousands of dollars. So the objective here would be, in other words, to set the funds aside into a trust, but it's a first party trust because it is their money. So their money needs to go into a first party trust. Everybody else's money can go into a third party trust. So different buckets for different people's monies. Settlement received from an auto accident, medical malpractice, product liability, again, putting Medicaid at risk, a first party trust to the rescue. Okay, let's move on to a third party trust. And a third party trust is for everyone else's money. So the disabled person's own money in a first party trust, third party trust does not have a Medicaid lien. Again, no Medicaid lien on the third party trust. So we really want grandparents, parents, anyone else that wants to make a gift or leave funds to the trust to do so in a third party trust so that it's not subject to Medicaid recovery. Beneficiary and or grantor or settler can be of any age. The grantor or settler either sets up a revocable or irrevocable standalone special needs trust, which can be funded at any time, or a testamentary trust that can only be funded upon death. So just depends upon what we can pull together. Let's see here. At the beneficiary's death, no need to pay back Medicaid. So what's powerful about the third party trust is that funds will stay with the family. They'll catch up with siblings or other family members, that type of thing. Whoever is specified, it does not, it's not subject to claim by the state like a first party trust is. Does not provide for basic maintenance needs like food, clothing, shelter that are otherwise provided by government benefits. Okay, a qualified disability trust, another one of the types of special needs trusts on the list earlier, qualifies for a $4,300 tax exemption. That was the case for last year. How does a trust become eligible for qualified disability treatment? There are several required criteria. It must be irrevocable. The trust must be established for the sole benefit of the person, and under age 65 at the time the trust is established, then it has to be irrevocable. So there's just several criteria. If it does meet the criteria for a qualified disability trust, then fortunately, it will enjoy this exemption, which means in many cases, the trust can function tax-free. That is, dividends, interest, and capital gains are not taxable because they fall under the exemption. So again, just some special arrangements that can be made where tax considerations are very important. Let's look at some examples here. Well, this is more actually on the third, on the qualified disability trust. So if taxes are a significant consideration, then we can look at a qualified disability trust. Okay, let's go on to pooled trust. This is, again, made popular by ARC of Indiana. And typically it's organized by a nonprofit in Kentucky. We have Life Plans of Kentucky, or again, Indiana, we have the ARC. The assets are pooled, but assets deposited for each trust beneficiary are accounted for separately. So the funds go together and are invested together, et cetera. But there's accounting to keep track of how much is on deposit for each trust beneficiary. Upon death of the trust beneficiary, remaining assets can go to the nonprofit, to Medicaid, or to the family, depending upon the type and design of the special needs trust. So you have some options available with this. While there is, in other words, who sets it up can have some say in a pool trust situation, but it does depend upon what type of trust. As an example, ARC has Trust 1 and Trust 2. ARC Trust 2 is a trust that is funded with the consumer's own money. And so as a result of that, the ARC typically retains 50% to help other trust beneficiaries who may run out of money, and the other 50% goes to the state. The ARC Trust 1 is the ARC Trust where you have the opportunity to dictate where you want the funds to go when something happens to the trust beneficiary. So this can be less expensive, and it may be the best case where resources to fund the trust are modest, and the parents are not sure who they can find to be a trustee. Okay, so we have some examples to look at. So this is pretty exciting stuff to see how these things actually work. So Ober 93 brought about the Miller Trust, called the D4B Trust, also known as a Qualified Income Trust. And this irrevocable trust is set up to receive monthly income in excess of $2,523, allowed to maintain disability, Medicaid, and Medicaid waiver services. So in Indiana, like I said, we're 1634, and if one's total income exceeds 2523, then they cease to be eligible for disability Medicaid, and they're at risk of losing their waiver. So again, what can they do? They can set up a Miller Trust. They can sweep the excess over the 2523 into the Miller Trust, and then from the Miller Trust, they can make withdrawals, or the trustee can, to pay for things for them. So two examples. Example number one, Daniel has special needs and is employed, earning $1,000 per month. He receives $458 per month of SSDI and $383 of SSI for a total monthly income of $1,841. That's $1,000 plus $458 plus $383. Earning income is under, let's see here. Earned income is under the SGA, or substantial gainful activity limit, of $1,350, and total income is under $2,523. If he stays under the $2,000 in resources, all is good. So his total income from all sources, Social Security, SSI, SSDI, earned income, and so forth, total income is under the $2,523, and all he has to think about is the $2,000 resource limit. If he stays under that, then he's in like Flint. However, in 2022, this year, his dad retires, making Daniel eligible for what's called adult child benefits. His total SSDI benefit increases to $1,600, and that's because the dad retiring allows the son, Daniel, to draw off of the father's record. So his total SSDI benefit now increases to $1,600. He is no longer eligible for SSI, so his total monthly income is $2,600, $1,000 in earned income, $1,600 in Social Security. That exceeds the $2,523 by $77 a month. So if Daniel, in this case, were to set aside his $77 into a Miller Trust account, then he would be seen as being under the 2523 limit and would be eligible to continue to enjoy available services. Okay, so let's go on to example number two. So Ted has special needs, and both parents die in an auto accident. He works part-time and earns $700 a month. His adult child survivor benefit is $1,900. And I know this for a Social Security benefit really seems large, but when it comes to survivor benefits, the limit or percentage that the consumer can draw off of the parent's record is as much as 75%. So if the full retirement age benefit that Ted's parent would have received was like $3,000 as an example, then 75% of that is $2,250. So we're seeing Social Security benefits, $1,900, $2,000 a month for adult individuals who are losing a parent, meaning parents passing away. That 75% really adds up to a large benefit. So in this case, though, he does have a part-time job. He's earning $700 a month. Then parent or parents pass away. He's drawing off of a parent at $1,900 a month. 700 and 1,900 is 2,600. So he's above the $2,523. We need to set up an ABLE account, sweep the $77 aside each month into the not ABLE account, but into the Miller Trust account. And then that would enable the Medicaid, disability Medicaid and waiver services to continue. So Miller Trust are income issues. The first and third party special needs trusts are resource issues. So different issues, different problems to solve, different types of trusts to use. Okay, enough about the type of trust. I know it's kind of complicated, but it really is exciting to help people solve these problems so they can continue to get the help that they need. Because if resources can be set aside into a trust, then that can be there for them to pay for things the government can't or won't. Just like earlier today, I was working with a gentleman whose son has CP and is non-ambulatory. So he wanted an electric wheelchair and he was having a horrible time with Medicaid, but there were resources in a special needs trust. So those resources in the trust are going to assist with that mechanical or electric wheelchair for their adult child. Okay, so this just shows the interaction between family members, trustees, and medical or social worker. All righty, so methods for funding a special needs trust. There are different ways. And by the way, I should pause again and remind everyone that questions are wonderful. If you would be so kind to ask, you can just click on the icon for chat and enter a question in the chat box about anything we've covered: government benefits, trusts, ABLE accounts, guardianship, you name it. We're really going through quite a few important subjects to the special needs community during the series. And I'm so thankful for the opportunity to share on this schedule that we've established. So methods for funding a third-party trust. And again, third-party trust means the monies are coming from someone other than the consumer with special needs, parents, grandparents, etc. So it can be through someone making a gift or putting the trust on payroll, meaning once a year or so much a month, they've got money going into the special needs trust. Life insurance as a beneficiary, where literally the special needs trust is listed as life insurance on, as a beneficiary on life insurance at work or personal coverage or whatever. Retirement funds, meaning leftover 401k or IRA or Roth IRA or a simple or SEP. So retirement funds that might be left can go to the special needs trust. The Secure Act exception is super because the Secure Act was passed January of 2020, right before COVID started. And it took away the opportunity to stretch the receipt of retirement funds from a deceased parent over our lifetimes, but they carved out an exception for someone with special needs. So that's just really exciting as to how a special needs trust can hold these, can hold an IRA, that type of thing, and continue to distribute over the lifetime of the trust beneficiary. Investment accounts via transfer on death, so that would be non-retirement investment accounts, can go to a special needs trust by instructions we typically call TOD or transfer on death. CDs via POD or payable on death, or property via a will. So there are lots of different ways to drive assets to a special needs trust and different vehicles to do so. So caregivers, grandparents, godparents, friends, GoFundMe accounts, all kinds of entities out there that and people that can contribute to a third-party special needs trust. Again, third-party means the funds are coming from someone other than the trust beneficiary. And then also annual or monthly payments. This is putting it on automatic, 100 a month, 200 a month, going into the special needs trust, whatever one feels that they could afford. Okay, and then it's showing here in this example, a large life insurance coverage of $1 million, and caregivers or others pay the premium for the insurance, and then the beneficiary can be the special needs trust. Also, as you see there at the bottom, the special needs trust can actually own the life insurance. And I had a case earlier today with a family from Lafayette where we're looking at the trust actually owning and paying for the life insurance. So that enables the life insurance to be in the trust, the benefit from the life insurance to fund the trust upon the death of parents. And the trust is actually paying the premiums on the life insurance. So it's not, the premiums are not a burden to the parents or anyone. So there's some really exciting strategies that we're able to utilize with special needs planning. This is an example of different types of life insurance. There's term, there's universal life, there's permanent life insurance, and there's also second to die coverage. Second to die coverage is the rage in two-parent situations. We probably use it 95% of the time as a guaranteed and dedicated funding source for the special needs trust. So again, very, very powerful that the that the life insurance can guarantee funding for the trust. If you've not heard of second to die or survivorship life insurance, it's a special type of life insurance that insures both parents together, and it guarantees to provide a death benefit for the trust when the second parent passes. So if you have a mom and a dad, whether married, unmarried, divorced, whatever, if you have a situation where we're concerned about the trust being funded when both parents are gone, then this would be life insurance that insures both parents together. And upon the death of the second parent, the life insurance company cuts a check to the special needs trust, guaranteeing that it gets funded. So I have access to most every company in the industry that provides that type of coverage. And so we're very keen to shop and find the best values for families, et cetera. But that coverage is discounted. So a fairly small premium amount can guarantee a really meaningful benefit to fund the trust with the second to die coverage. I did have a question that popped up about the Secure Act. And so let's just briefly go back to that. Part of what the Secure Act did was Secure Act exception. It took away the opportunity in most cases for an individual receiving retirement funds as a death benefit from a parent. So if you have a parent that has a 401k or an IRA or that type of thing, and they pass away, and you're listed as a beneficiary, if you're not a spouse, then you have now 10 years to receive those qualified funds and to pay taxes on them. Prior to the Secure Act, in many cases, a person could stretch the receipt of that over their lifetime, and as a result, pay a minimal amount of taxes. But the Secure Act represented an opportunity for the government to get the tax dollars quicker. And now the Secure Act provides that if you're not a spouse and you're not a disabled individual or a special needs trust, that you have 10 years to receive the retirement funds that were left to you. And so basically, Uncle Sam wants their tax dollars within 10 years. There was a carve out, though, from the Secure Act for disability trusts. And so a properly established special needs trust can qualify for that exception. And what that provides for is that, like it used to be before the Secure Act, a special needs trust can stretch out the receipt of those qualified retirement funds over the lifetime of the trust beneficiary. So as opposed to having to take all of the funds and pay taxes on it within 10 years, the special needs trust can receive the qualified funds upon the death of the family member and can stretch out the receipt of those over the lifetime of the trust beneficiary. So that helps to minimize taxes like we used to have before the Secure Act for most everyone. Now the privilege of being able to stretch the receipt of qualified funds following a schedule over the lifetime of the trust beneficiary is pretty unique. So that's something that we were able to achieve. Okay. This in a little more detail divides down government benefits from that is means tested versus not means tested. So on the left, you have Medicaid, Medicare, and so you have a host of government benefits. Government may help with healthcare, with room and board, this type of thing. But special needs trusts are designed to take care of everything else. So the special needs trusts are a person's everything else. And I'm very passionate about this because 30, 40 plus years ago, people were frequently institutionalized that had disabilities, especially intellectual and developmental disabilities. And so the government saw their duty to provide food, shelter, and healthcare. In many cases, these people did not live that long. And that's because simply having food, shelter, and healthcare does not give a person purpose, does not provide for socialization. It doesn't give them a reason to hang around, and they didn't. So with the advent of IEPs and 504s and Medicaid waivers and waiver services, and our young people being in the home and community and taking on part-time jobs and so forth, lives of individuals with special needs or disabilities are so much more meaningful than they were decades ago. And so the question therefore becomes, wow, the government's not doing all of that. If something happens to the parents, how do all those good things continue? And the answer is, in most cases, is by the parents setting up a special needs trust, funding it in some way, so that when something happens to them, funds flow into the special needs trust, and therefore resources exist that do not count against the family member with special needs and can be used to enhance their quality of life. It is huge, huge. It can literally affect how long they live and how much enjoyment, how much joy they have during their years on earth. You get to select whoever sets up the trust, gets to decide who is going to be the trustee. And from a professional or corporate trustee, there are some services that one can expect to receive, and some of those are outlined here. Providing full trust accounting and asset reporting, preparing and filing all income tax returns, relationship manager, access to secure website, so forth and so on. So there are a variety of trustee options. Parents can serve as the initial trustee at the time the trust is set up. And then someone can follow the parents. It can be an aunt, an uncle. It could be an adult sibling of the child with special needs. You can have a trust company or trust department or someone like the ARC serve as a backup trustee, et cetera. So there are options to choose from. You don't have to have a family member ready to do it all. We work with every measure of situations to figure out who can do what. There are generally 3 steps in the process of setting up a special needs trust. One is to gather information together, a draft of the new trust document, a copy of the original document if there was previously a trust, and a list of assets that will fund the trust. Trustees are most often the parent, as we just said, or it can be a professional trustee or trust company. Upon receipt of the draft, the trust company will review the documents to confirm they can efficiently administer the terms of the trust. Trust company is available to discuss the trust with the grantor or the person setting it up. And then parents would review the draft and so forth. Frequently, of course, special needs trusts are set up as a part of an estate planning process that includes also getting wills, durable powers of attorney, healthcare directives, living wills, etc. If there are any questions, now would be a great time to put them in the into the chat box. And again, I invite you to ask questions about anything that we've covered to date or anything else special needs. And so feel free to do that. We'll try to answer questions as we get toward the end of today's presentation. Step 3, upon acceptance of the trust, then a formal review, the investment company creates the trust account, so forth. So we have a healthy number of trust accounts for individuals with disabilities, and it doesn't require a large amount to get an account open, not at all. So the role of a special needs planner like myself includes understanding the financial needs of the individual and how social, medical, and legal needs impact their care plan, providing a financial needs analysis, coordinating financial strategies with the attorney and other professionals on the team, offering financial options that make the most sense based on the needs of the trust beneficiaries, and working with a family to help ensure that benefits such as Medicaid or supplemental security income will not be unintentionally jeopardized. Knowing the questions to ask about your current and future needs, helping the client caregiver, or excuse me, the caregiver maintain the lifestyle of their loved one with special needs. So I'm working with trusts every day of the week. In fact, when I get off of the Zoom call today, I've got several trusts I need to work on before the market deadline of 3:45 p.m. So this is making funds available to cover expenses like the $2,500 for the electric wheelchair and so forth. So I'm working with trust accounts every day of the week, helping to meet the needs of trust beneficiaries. So obviously, as a result of my experience, I'm in a unique position as to being able to assist trustees with what the trust can pay for and what it cannot pay for, and how to affect those disbursements, et cetera. My contact information is up on the screen at this point. I maintain offices both in Indianapolis and Louisville, and both addresses are there. In addition, I have a toll-free number, so very easy to contact. Again, there's a toll-free number, email address, website as well, and 2 office locations. I certainly do not serve alone. There's a team of people that I work with. I'm so very thankful and grateful for. Currently, we have 3 on staff. We're going to be welcoming a 4th, which will be an intern through the spring and summer here very shortly. Just trying to keep up with all the needs that people have, and and take care of everyone. Questions now would be a really good time. While we're doing that, I want to thank Lisa so much for being such a gracious host and helping make the workshop series that we're doing possible. I think we have a 4th, if I'm correct, Lisa, in April. And so I should put a plug in, or whatever they call it. So we're going to be covering life care planning. And so it is it's a great workshop because it takes a timeline and kind of talks about the special needs journey from younger ages to older ages, and things that come into their lives and move out of their lives, and different planning strategies to help preserve quality of life along the way. We will be talking about the letter of intent in April, which is amazing. A letter of intent is a caregiver guide or owner's manual for the individual with special needs. And so we'll be talking about that. We will be talking about selected parts of the different materials we've covered in the earlier workshops, all rolled into one, with the title being Life Care Planning. So with that, again, thanks so much, Lisa. Do we have the date for the next workshop?
I was going to say the next workshop is on April the 29th at 2 o'clock in the afternoon.
Wonderful. All right, Lisa, thanks so much for everything and everyone taking your time. Again, thanks to you all. Very much look forward to seeing you in April.
Well, thank you, Gordon. Have a good afternoon, everybody.